everybody knew about the Duke lacrosse case. And everyone heard about it. So what we started to do was look at that model, and how could we use that. And I'll get to kind of how we used North Carolina in a moment. About 12 of the states right now practice absolutely closed discovery based on the federal system, this is what they would say. The rest fall somewhere in between. Montgomery County, their local rule 3.01 calls for open discovery basically because it is the fairest and most expeditious administration of criminal justice. What open discovery in their estimation did was it eliminated delay, unnecessary expense, and all other impediments to a just determination of criminal cases. This is one of the examples that we looked at here at a local level, and when we started kind of figuring out how to present this, we drew upon that. It's important to note that there's not been a single jurisdiction, either in Ohio or outside of Ohio, that's ever gone back. So there's never been an open discovery state, county, city, whatever it is, that went back to a closed system. So as I said, I'm going to go real fast on this, and I apologize, there's a lot of info to get here too. The game plan, when this all started, was again to look at the other states. And the first thing that we did was the OECD LA seminar in Cleveland. And what we did was Jim Cooney, who was one of the lawyers in the Duke lacrosse case, was actually a Cleveland Marshal at our seminar, and I had him come up and talk about that case. And he showed, it was a wonderful presentation, and he showed that if it were not for open discovery, how those young men would have been on trial and subject to conviction. And he showed that it was only the result of open discovery that allowed them to be successful in that case. I think that a good spark in this case was him being there and some of the folks that took this as a cause in the media also being there and so struck by this. And then the momentum started going forward. The other thing that was very clear was that all the battles that have been going on over this for the last 40 years have been the defense versus the prosecution. And at the end of the day, unless you're touched by the criminal justice system, you're not really going to be so concerned about it. People don't know what goes on in the criminal justice system. They get snippets at night on the news, but until they get involved, and we see it all the time with first offenders and their families coming in, they say, gee, I didn't know it ran this way. So what we really had to do was kind of expand this out and let the public know what was going on. Through the assistance of several bar associations, Plain Dealer, we were able to bring forward over 10,000 signatures from across the state calling for open discovery. The media from November of 2007 up until only a few months ago were covering this pretty routinely. Cleveland, the Metropolitan Bar Association, the Northern Minor Bar, Ohio Association for Justice, they kept coming in. And so now for the first time what we had was we had all the civil bars involved in this. We had people outside of the criminal realm saying, wait a second, we really do need to stop and take a look at this. We looked at some other local counties here throughout the state that were working just fine, and actually some of those prosecutors or lawyers calling for open discovery saying it worked for them. The other thing that I thought was very compelling, what I hold in my hand, is a A&E video called Blood on the Tracks. And what that was just a Saturday afternoon, I was sitting at home with my wife, and this was the coverage on A&E of the young man's case, in the case of State versus Ismail Irizarry. And what that was it was a murder case in Cuyahoga County. And A&E had exclusive inside access to this whole murder investigation and going through it, and it covered everything. The witness interviews, the juvenile proceedings, consultations with the experts. I mean, this was so far beyond what we'd ever and this really was inside of a criminal investigation. So I'm watching this and I said, geez, how does the prosecutor's office feel about this thing being so in depth? And when what and how. All they have to do is log on to the case and they see it. So it is working there. All right, so let's get on to, I'm going to skip a couple slides, and let's get on to the new proposed rule, which you all have. This rule, as I said, was the result of a lot of work from the defense bar and from the Prosecuting Attorneys Association. First thing that I think that you'll find different from Rule 16 is, although it may encompass the same spirit as the current Rule 16, we really felt that it was necessary to let everybody know why Rule 16 was important. What is Rule 16 supposed to do? And for purposes of my presentation here today, you'll see in red here the rights of the defendant. Criminal Rule 16 is in place for the rights of the defendants. We look back and we never saw that anywhere. So when you always hear we got to protect the victims, we have to protect everyone else. That was a big debate, just simply getting the rights of the defendants in there. But once there started to the acknowledgement on both sides of the aisle that yes, witnesses do need to be protected, victims, but also defendants, we started moving ahead. It's important to note that the rules right now, even just as far as the simple timing on this rule change. It used to be 35 days after arraignment, 7 days prior to trial, and now it's going to be pursuant to Rule 16I that the defense shall make the request for discovery within 21 days after the arraignment or 7 days prior to trial or sooner. And if you go through it, as I said, I think it's going to take a while, truthfully, to kind of get used to the rule. We've been working on it now for a couple of years, actually, and it's going to take quite a bit. But I think once you go through it a few times, it's going to work itself out. There's been some concern as to certain provisions of it. What does this mean? And I think as it plays out practically, this will be a very fluid and very smooth transition for everyone. We are allowed, pursuant to Section B, there's subsections 1 through 7, now reported statements by defendant or co-defendant, we get that now. Criminal records, we get that. Lab reports, fine. All peace officer or Ohio State Highway Patrol reports. We don't get that now in closed discovery jurisdictions. The reason that there's this added State Highway Patrol